First this morning I told you about a huge decision destroying the ATF and their frame and receiver rule. Well, now I'm going to tell you about another huge victory that came in just about an hour ago out of California. And it's one of those ones I've been hinting at for weeks now that we had some bombs about to drop. This is one of many. This is actually huge. This is the restrictions on California. It's the Unsafe Handgun Act, where you had to have things like a loaded chamber indicator, magazine disconnect, and then ultimately the microstamping requirement that we've covered, I don't know, years ago when it was put into effect. I'm going to read you right from this case because it is hot off the press, and I want to just want to explain to you that we are living in great times right now where the gun control pillars are just being destroyed by the Bruen decision and that pesky thing called the United States Constitution. Guys and gals, if you think the Second Amendment and the U.S. Constitution are more important than basically anything else out there, then like the video and share the video, and don't forget to subscribe. That will help us out greatly. Let's jump into this lawsuit. As always, we'll start out on page 1. This is called Bolin v. Bonta, but you can see this is Lance Bolin, Mario Santillan, our friend, fellow gun tuber Reno May, Jerome Schammel, and the California Rifle and Pistol Association, Inc. Let's start with the introduction here by the judge, because this ruling is phenomenal. It says, the Second Amendment guarantees the right to keep and bear arms for self-defense. That right is so fundamental that to regulate conduct covered by the Second Amendment's plain text, the government must show, more than that, the regulation promotes an important interest in reducing accidental discharges or solving crime. Rather, to be constitutional, regulations of Second Amendment rights must be consistent with this nation's historical tradition of firearm regulation. California's Unsafe Handgun Act seeks to prevent accidental discharges by requiring handguns to have particular safety features. First, the UHA requires certain handguns to have a chamber load indicator, which is a device that indicates whether a handgun is loaded. Second, the UHA requires certain handguns to have a magazine disconnect mechanism, which prevents a handgun from being fired if the magazine is not fully inserted. Third, the UHA requires certain handguns to have the ability to transfer microscopic characters representing the handgun's make, model, and serial number onto shell casings when the handgun is fired, commonly referred to as microstamping capability. No handgun available in the world has all three of these features. These regulations are having a devastating impact on Californians' ability to acquire and use new state-of-the-art handguns. Since 2007, when the chamber loaded indicator and the magazine disconnect requirements were introduced, very few handguns have been introduced for sale in California with those features. Since 2013, when the microstamping requirement was introduced, not a single new semi-automatic handgun has been approved for sale in California. That is because the technology effectuating microstamping on a broad scale is simply not technologically feasible and commercially practical. The result of this is that when Californians today buy a handgun at a store, they are largely restricted to models from over 16 years ago. In this case, plaintiffs Lance Bolin, Mario Santillan, Reno May, Jerome Schammel, and California Rifle and Pistol Association, Inc. allege that the UHA's CLI, MDM, and microstamping requirements are unconstitutional, contending that they violate the Second Amendment under Bruen. Before the court is the plaintiff's motion for a preliminary injunction enjoining California from enforcing those requirements. Because the plain text of the Second Amendment covers the plaintiff's proposed course of conduct of purchasing state-of-the-art handguns, and the UHA's CLI, MDM, and microstamping requirements are not consistent with this nation's historical tradition of firearm regulation, plaintiff's motion is granted. So the Unsafe Handgun Act was enacted in 1999. It was tweaked in 2007 to add the loaded chamber indicator and the magazine disconnect, and then again in 2013 for the still didn't exist yet microstamping technology required today. Now, the first two features were pitched to stop accidental discharges, and the third one was pitched to help solve crimes, all of which was BS because it's just looking to stop the sale of handguns in California. As a result, none of the 832 roster listings meet the current definition of a handgun that is not unsafe. Not one of the handguns currently being sold in California has a CLI, MDM, and microstamping ability. Every single handgun on the roster is a grandfathered handgun, one the California legislature now deems unsafe. As a reminder, none of these rules apply to law enforcement, so they can have safe guns, but the people who the Second Amendment covers can't. There are 2 steps in the Bruen framework. First, courts determine whether the Second Amendment's plain text covers the individual's conduct. Second, the government bears the burden to show that the regulation is consistent with the nation's historical tradition of firearm regulation. Bruen's first step asks whether the plain text of the Second Amendment protects the plaintiff's proposed course of conduct. The first step in assessing whether a regulation violates the Second Amendment is to determine whether the plain text of the Second Amendment covers the conduct regulated by the challenged law. The Second Amendment reads, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." The first step under Bruen, therefore, is to determine whether the law at issue infringes on the right of the people to keep and bear arms. The challenged UHA provisions unquestionably infringe on the right to keep and bear arms. Plaintiffs seek to purchase state-of-the-art handguns for self-defense. The UHA prevents this. To acquire the latest model of a semi-automatic handgun, plaintiffs must buy one secondhand if they can find one at a high markup. Put differently, under the UHA, Californians must rely for self-defense on handguns brought to market more than a decade ago. Since 2007, when the CLI and MDM requirements were added to the UHA, only 32 new semi-automatic firearms have been added to the roster of over 800 handguns. Not a single new semi-automatic handgun has been added to the roster since May of 2013, when the microstamping requirement was implemented, requiring Californians to purchase only out-of-date handguns for self-defense without question infringes on their right to keep and bear arms. So the reason I'm bringing this to you is this is huge, obviously, for Californians, but there are other states that have rosters. Massachusetts is one. And as this crumbles, Massachusetts will crumble. And that's why I bring these to you. But there's more. Wait till you listen to what the government said. Nevertheless, the government contends that the plain text of the Second Amendment does not protect the plaintiff's proposed course of conduct because plaintiffs are still able to purchase some firearms and therefore keep and bear them. The CLI, MDM, or microstamping requirements do not prevent plaintiffs from either keeping handguns in the home or carrying them in public for self-defense. But a law does not have to be a complete ban on possession to meet Bruen's first step. The Constitution presumptively protects plaintiffs' proposed conduct. The burden now shifts to the government. Since the UHA provisions implicate conduct protected by the Second Amendment, they are presumptively unconstitutional unless the government can meet its burden to demonstrate that the relevant UHA provisions are consistent with the nation's historical tradition of firearm regulation. And what they used to try to prove it was old laws from the 17 and 1800s of Massachusetts and Maine, where people had to prove that their barrels were okay, and then a powder storage law. Absolute horse BS. Horse BS? Or BS or horse shit? Either one, you know what I mean. Because plaintiff's proposed course of conduct is covered by the plain text of the Second Amendment, and the government has failed to proffer any historical regulation analogous to the UHA, CLI, MDM, and microstamping requirements, plaintiffs have shown that they are likely to succeed on the merits of their claim that those requirements are unconstitutional. Conclusion: the Second Amendment enshrines a fundamental constitutional right for law-abiding citizens to keep and bear arms for self-defense. Increasingly, in modern times, with the ubiquity of guns and our country's high level of gun violence, ordinary law-abiding people feel a need to possess handguns to protect themselves against violence. This may be because they live in high-crime neighborhoods, or because they must traverse dark and dangerous streets in order to reach their homes after work or other evening activities, or because they reasonably believe that unless they can brandish or, if necessary, use a handgun in the case of an attack, they may be murdered, raped, or suffer some other serious injury. Californians have the constitutional right to acquire and use state-of-the-art handguns to protect themselves. They should not be forced to settle for decade-old models of handguns to ensure that they remain safe inside or outside the home. But unfortunately, the UHA, CLI, MDM, and microstamping requirements do exactly that. Because enforcing those requirements implicates the plain text of the Second Amendment, and the government fails to point to any well-established historical analogs that are consistent with them, those requirements are unconstitutional and their enforcement must be preliminarily enjoined. Accordingly, plaintiff's motion for a preliminary injunction is granted. Cormac J. Carney is the judge, U.S. District Court, Central District of California, Southern Division. Boom, another huge decision where a judge says, you know what, the government's overstepping their bounds, they're violating people's rights, and we're going to put this injunction in place to stop them. Now, this isn't the end of it. There's still time in this case. It's still going forward. And of course, California will probably appeal to the 9th, to try to stop this, because California never takes a loss until it's rammed down their throat with no other steps for them to take. And we know Gavin Newsom has his eyes in the corner office in Washington and DC, so he wants to be that guy that says, look what I did, y'all. I stopped guns from being sold in California. You can't get new guns here, not since 2013. Can't get a lot of them since 2007. Look what I did. And that's exactly what this is. It's a violation of our rights. It's grandstanding for political expediency, and all of it is coming crashing down thanks to Clarence Thomas's so eloquently written decision in the New York State Rifle and Pistol Association versus Bruen. I want to personally thank all of the plaintiffs. I want to thank all of the attorneys who have been working so hard on this case and the other cases in California that are just about to drop as well. And if you want to stay up to date, guys and gals, there's a ton of cases we're about to hear wins on. If you want to stay in the loop, then subscribe to this channel. Let your friends know about Guns and Gadgets. They love guns. They love Second Amendment rights. They love to carry a gun. They need to know what's really going on. And this is the place to do it. Until we see each other again, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. And do it without microstamping, a magazine disconnect, or a loaded chamber indicator. I'll see you all in the next one. Take care.